A deposition, much like a trial, is usually won or lost in the preparation. On today's legal brief, we're going to show you exactly how to prepare for a deposition. Remember, by failing to prepare, you are preparing to fail. Is that too cheesy? Okay, so you have decided that it's time to depose a witness. 90% of attorneys don't go about this the right way, and we want to get you into the top 10%. So don't worry, I got your back. Most lawyers at this point are going to email their assistant to schedule the deposition and then ask them to send out the notice of deposition, and then maybe a couple days before the deposition they will begin to prepare. Wrong, wrong, wrong. The first step after deciding to depose someone is to make your outline/checklist. I usually write this in a yellow pad, but just for you, I've typed out a standard deposition outline checklist because you wouldn't be able to read my handwriting normally. So here it is. This is what I might ask for a defendant's deposition in a car accident case. Now, at the top, I leave room for the deponent's name so I don't forget, and also leave a space for the court reporter's name. It's always easier to order the transcript if you have her or his name. Next, you need to have an organization to your deposition. That's the key. So most of the time, I organize my depositions by the allegations in the complaint, which are generally the elements of the cause of action and then also the affirmative defenses. 90% of the time, this is going to work for you. As you cover each element that you need to prove, you simply go back here to this top sheet and cross it off. For example, the first thing on my outline is venue/jurisdiction, so I just really need to prove that the accident occurred where I filed my lawsuit and maybe prove that the defendant resided in the county where we filed. So I just need to ask the deponent, did the accident occur in Orange County? And maybe, did you live in Orange County at the time of the accident? And that's it for that, and I can cross it off. It's that simple. But then you never forget to ask the question. The second part of this checklist is the documents you want to get in the record. Now, this is actually the more important part. Here you list under each section what documents you want to get into the record through the deposition for that section. Once you get it in, you cross it off and then jot down next to it what the exhibit is. For example, the defendant's driver's license was entered first, so it's Exhibit A, so I just write A next to that document. Now you have a way of making sure that you cover all of the elements and cause of action, and that you get every bit of evidence you want in. Now look down to B, duty of care. Maybe I want to get in that the person was going from such and such a place to such and such a place, and I want to show them a Google map and have them write on the map where they were and where they were heading to. That is going to be document 1 that I have to make sure I get in, and I can check that one off under duty of care and then write in that it came in as Exhibit B. Next, breach of duty, I might want to get in pictures of the scene so I can show the pictures to the witness, say are these pictures from the scene, and then get them attached to the deposition transcript as Exhibit C under breach of duty. Same thing with damages. Maybe I want to get in that the defendant himself or herself actually had to go to the hospital and receive medical treatment, which kind of shows that my client's not crazy because saying that she was hurt because that person was hurt as well. So maybe I want to get in those medical records. So I write it down under damages to make sure I don't forget to get it in. Same thing, for example, under affirmative defenses. I can ask them about affirmative defenses. Maybe they've listed a Fabre defendant saying that the car was repaired, but it was improperly repaired, and therefore that led to, maybe that caused the accident. I can get in those repair records under paragraph 3, affirmative defenses, document 1, which could come in as Exhibit E or F. So those are documents listed under each element of what we've alleged in the complaint and under each affirmative defense. That's the easiest, and in my experience, the best way to do it. Okay, so that's the outline checklist. Now here's step 2, and also where a lot of lawyers mess up. After you have your outline checklist, you ask your assistant to schedule the deposition, but you make sure that you're going to review it before it goes out. And let's look at a sample. The first thing to check is whether you put the other side on notice that the deposition is being videotaped. Here we did not, so we cannot videotape. Once this goes out, you can't change that. Next, you refer to Exhibit A for the documents to be brought as the ducis tecum. And then what is Exhibit A? That's right, it's the documents that you have listed on your outline checklist. You've already listed every single document that you want them to bring, and therefore you simply cut and paste that over to Exhibit A and maybe add in a couple things that you may or may not want to use. Okay, now you have the deposition set up correctly with some thought, and when you sit down to prep the day before, you will be able to focus on the witnesses, your excellent cross-examination techniques because you watched my other videos, and most importantly, you will not be driving back to the office afterward and suddenly realize that you forgot to ask the most important question. I hate that feeling, don't you?